Okay, thank you so much for joining me this afternoon, my time, this morning, your time. I will start by acknowledging that I'm on the land of the Darrell people and send my respects to elders past, present and emerging. Thank you everybody for joining me from beautiful Scotland. We might start, if it's okay, with a round of introductions. Claire, would you like to start?
Hi everyone, I'm Claire Houghton. I'm a researcher at the University of Edinburgh.
Thank you, Claire. Marsha?
Well, I would turn my mic on if I'd remembered to turn it off to begin with. Good morning, well, good afternoon, whenever everybody's watching this. I'm Marsha Scott, and I'm Chief Exec at Scottish Women's Aid, which is Scotland's national domestic abuse advocacy, research, and service umbrella.
Thanks, Marsha. Sam?
Good morning, I'm Sam Faulds, the Detective Chief Superintendent. I'm Head of Public Protection for Police Scotland, which includes domestic abuse, but all matters relating to violence against women and girls.
Thanks, Sam. Gillian?
Hi there, I'm Gillian Faulds, no relation to Sam Faulds, but I am Police Scotland's lead on domestic abuse, so I support the delivery when that's policy and practice. I've also got the Domestic Abuse Task Force who deal with your serial perpetrators, and we target them proactively across the country, and also in charge of our Domestic Abuse Coordination Unit who oversee the policy side of the business.
Thanks, Gillian. And Tracey.
Good morning, I'm Tracey Gray and I'm a Detective Chief Inspector with Police Scotland, and I was the operational lead for the introduction of the Domestic Abuse Matters Scotland training and involved in the implementation of the Domestic Abuse Scotland Act back in 2019.
Thank you so much, Tracey. So we might just get started with a question to Claire. Claire, yourself and colleagues at the University of Edinburgh and the University of Stirling performed the empirical research that makes up the interim evaluation of DASA, which was released in January. Can you tell us a little bit about what adult and child victims and witnesses told you in that research, as well as what evaluation framework needs to be in place from the beginning of implementation, particularly around ensuring survivors' experiences are centred?
Absolutely. Yeah, I'd be delighted to talk about my research with Fiona Morrison and Camille Warrington here, but also with our partners who are here, and others, including the Crown Office and the court advocacy programs. So yeah, we interviewed in depth victims and witnesses about their child-sighted witnesses, so that's why I'm using the terminology, the legal terminology, about the Act. And in terms of the definition contained in our Act, which is slightly different than yours, I've just been looking at yours, but has some similarities. Ours captures a range of abusive behaviour, including physical and sexual, as well as elements of coercive control, though coercive control isn't explicitly named, but lots of behaviour such as monitoring, surveillance, etc., that's in your Act. And when asked about the Act definition, lots of the victims and the children, in terms of the aggravator, which I'll come on to, felt this did reflect their experience of a range of abusive behaviour over time. For us, it's about at least 2 occasions, but yours, you talk about repeated and continuous, and that really encapsulates what people were telling us about their experience. That repeated and continuous abuse and psychological abuse being a major factor in this, which is, you know, the major change in our law. But they felt that psychological abuse was the most difficult to talk about themselves, to friends and family, as well as to report, but also to evidence within the system. And many talked about collecting their own evidence, having difficulty in really making evidence count about verbal, online, social media, email abuse, a lot of stalking behaviour, a lot of monitoring, people being in places, and how difficult that was to become part of an investigation. And also that talking about ongoing rather than one incident was still difficult and time consuming, and more difficult than a one-off incident to capture, but far more reflective of their experiences. So psychological abuse is still a major issue. How do we actually include that and evidence that? But also in terms of harm to children, we have a child aggravator that encapsulates a range of behaviour in relation to children. And parents and children in the study felt that harm to children still wasn't adequately recognised or captured, nor that they felt that it didn't impact sentencing. So one of those cases it involved a child aggravator under our Act, which meant that sentencing could be increased through a child being adversely affected by the domestic abuse. And yet, despite there being 10 child witnesses, there was just one child aggravator. But overall, that aggravator has been used in about a quarter of DASA cases. DASA is our shorthand for our Act. And there were 3 non-harassment orders that involved children. Again, the parents and children didn't understand why there weren't non-harassment orders for every case involving children, but felt that this was a positive step forward to involve children. And the children don't have to be the cited witnesses or part of the child aggravator. It can be children that are associated with the partner or ex-partner, i.e. the victim in law. So the potential was there, but in terms of the use of the new offence, they felt it wasn't used adequately. There was a lack of application of the fullness of the law. We involved 10 cases that were not DASA, so they were domestic abuse aggravated crime. The majority by far of our crimes are still, is it 94% if I've got my stats right, Sam? Are still domestic abuse aggravated crimes, so common assault, threatening and abusive behaviour, not the ongoing course of conduct. And they felt that every one of their cases involved an ongoing course of conduct, so the DASA wasn't being applied in every case that it could be. They felt that initial response could be improved to look at the experience holistically, but also that it's difficult to capture in the moment, and that the follow-up was really important. So there were examples of good practice, like one woman speaking about how the police officer and the health worker together, when she said she was frightened for her baby, actually helped her piece the jigsaw together over time. So they actually helped her identify what she experienced as domestic abuse, and also that it was a DASA case, that it was over time. So that's what we want. I think all of us around the round table here want, but that wasn't happening. And this 3 years, the first couple of years of the Act, they felt that there wasn't enough involvement of the victim and the witness in building the case, that they could have offered a lot more. They felt there was a lack of contact with the procurator fiscal, like our prosecutors, which is true. That doesn't often happen unless it's a High Court case, and the majority of their cases are in summary court. Court buildings were a site of abuse and trauma. They called for women and children to be removed from court. We also interviewed two men, one of whom agreed with that too. Special measures such as screens were inadequate, that needed to be remote at best, and really the kind of Barner House approach, which you'll have heard of for children, was the kind of approach that they wanted for adults and children. And the sentences was wholly inadequate in their view. It was mainly community sentences, but the non-harassment orders offered some protection for some, and they were worried about the length of those, and that they didn't include a wider range of people, including third parties, not just children. It is possible to include children. So for some, though, the cross-examination, though it was the most traumatic element, they felt it was the only chance to tell the full story, which isn't true. The statements and the way the case is put across should be a chance. So the kind of, I suppose, the vision for that this is a chance to tell the whole story. In reality, that's often not the case, and perhaps that is because we even within this, we still focus on the incidents we can more easily get evidence for. So the 2 occasions that were, because in our Act, it's about 2 or more occasions. There always were more than 2 occasions, but there might be a focus on those couple of major or more physical or hospitalized, incidents in their case. So they felt that in the end, the sentencing did not reflect the sustained level of abuse, severity, of the crime. But there were some steps forward, and there was potential. I suppose it was hopeful, like there was potential, but we're not getting there yet. We're far from getting there. In my view, far from the gold standard in terms of children. Children are not co-victims. Children are not, harm to children's not being recognised adequately. But we need to look at NHOs and child aggravators and how they're working and what's working well as what isn't. So yeah, a lot more public awareness and professional awareness about the Act. I know there's major steps been taken, but they didn't feel they understood quite what was a crime yet. And they certainly felt that most, not all, but most professionals they came into contact with didn't understand the elements of a crime, including psychological abuse, especially. So there's lots more to say, but I think that's a good introduction in terms of what the victims and witnesses said. And yeah, in terms of your evaluation question, so we had a 3-year report to Parliament. So this research was just as part of the report to Parliament. Other partners contributed as well in terms of statistics. But unlike your Act, we don't have a task force written into the Act. That looks really positive to me, and your reference groups. We are still working with government. I met them only yesterday about how to implement the Act and implement the findings, and we work together really well as partners, but there's no structure at present, and where we go from here is still to be worked out with a new minister now as well. So I think that these interviews, these in-depth interviews, are a small part of a much bigger picture, and we need to be looking at a wider range of victims and witnesses, more children. We need to be finding out from professionals what's working, what isn't, looking at cases from many different angles and working out what we can do. But the victim survivors, women and children, and the 2 men that were involved certainly call for a kind of more radical look at all victim survivors of domestic abuse in the system. So yeah, thank you.
Thanks so much, Claire. Marsha, did you want to add to that?
Yeah, I mean, there's so much in there, and so much of that evaluation reflected what we've been hearing from survivors. So it was great, Claire. It was so good to have it, documented and on paper. But just in terms of evaluation generally, it was actually an amendment the day the bill was passed from an opposition party that required that the Scottish government report back at, I think it was 3 years after implementation, to the Parliament about how the law was working, which was very welcome from our perspective. Unfortunately, the government didn't start planning that evaluation until about a year before the time was up. Now, COVID was involved in all of this, and however, there was still no excuse as far as I was concerned. Of course, there never is. But so most of the data wasn't available because people weren't collecting it from the beginning. Service organizations weren't asked to, gather disaggregated data about how many BME women were accessing advocacy under the new law. I'm quite sure the police weren't being asked to track, certain critical things that we wanted to know at the end of the 3 years. And unless you're asked and you don't have to count it already, you don't. So, I think one of the things I would really, really recommend, and good on you folks for talking about this before the bill is passed and implemented, is to be very explicit about what evaluation will look like, what kinds of information needs to be gathered from the very beginning, probably prior to implementation, so that when you get 2 years or 3 years down the road, you actually have a good picture of what's going on. So, for instance, some of the examples for us would be, we know that there's child aggravations asked for in about 24% of cases, but because of the way data is gathered by the Crown Office, we don't know how many of the total cases actually had children in them. So probably it was about, I think Sam told me once, it was probably about 35%. So we know we're well under. I would expect that child aggravations would be asked for in almost every case where there's a child. But we don't have that data. We know that as Claire referenced, that quite a small percentage of the total domestic abuse offenses are under Section 1, and it's still a good number. I don't want to minimize that. It certainly was many times what it was when that first law was passed in England and Wales. And I think our Crown Office has taken up the charge for, with enthusiasm. But what is it? Why is it that so many of those cases? Because absolutely, Claire, our experience is that, find me a domestic abuse case. That's not, situational couple violence. It's not a fight, but a domestic abuse case where there's no coercive and controlling behaviors, and I'll be astounded. So the fact that we have only 4% of our total offenses are under DASA, why is that? Well, we don't have the data to tell us the answers to that. So those are the kinds of things that I'm really hoping you aren't asking at the end of 3 years that we are, and good on you. And the other thing is, implementation was a flicker in our brains at that point when we were passing all of this. And thank God the world of policy has moved on to understand that if you don't plan for implementation when you're doing your original planning, then you're going to struggle in the dark for a long time. And I'll leave that. I got a couple of other things about what Claire says, but I know it wasn't my turn to talk, so I'll stop.
Well, no, while we're on implementation, maybe we can jump to a question for you, Marsha, on that. You have previously commented that coercive control is not an add-on, but it's the dynamic that underlines all domestic abuse. How do we ensure that this is embedded in the implementation of the coercive control offence? And can you speak a little more on how we may embed cultural reform across the legal system and in economics and health and education?
Well, that was just a small question, Bridget. Thanks. Well, the folks in the call will be like, oh God, here she goes again. It's all about gender. The reality for us is that if you can't understand coercive control if you don't understand how the gender dynamics of families and communities in Scotland, and of the UN setting for all forms of violence against women and girls, which is the historical oppression of women and girls. And that sounds like, I'm just writing a PhD or something, but actually it comes down to the minutiae of women and children's lives. So, who is it that manages the family finances? Who is it that has access to the paid labor market and can make an adequate choice about whether they want to live with somebody else or not and still support their children? Who is it that is not at the tables when resources are distributed in a local authority and people don't invest in homelessness services for women and children fleeing domestic abuse? So those are the kinds of things that, and I don't need police and sheriffs and solicitors to be able to write a treatise on gender. What I do need is for them, and what they need is when there's a woman or child standing in front of them telling them about domestic abuse, that they understand the sequelae of all of that gender dynamics, and how choices are constrained, and why perpetrators are enabled to be abusive and coercive and controlling. So how do I think we fix this? Well, I know that my lovely sisters from the Police Scotland are going to talk about their training, and I know that the people who were involved in that training were thrilled with it. I think but we're fooling ourselves if we think training is a silver bullet. Possibly that wasn't a good thing to talk about in policing. We're fooling ourselves if we think it's a panacea. So, it's like flushing money down the toilet, and if you don't have an implementation plan around it, if you don't have structures that hold officers, that hold sheriffs, yeah, good luck on this one, accountable, that hold everybody accountable for understanding the dynamics of what they're looking at and for changing their behaviors as a result. And if you're not doing all of those things, and I'm not sure I would call that culture, Bridget. I think people use the word culture when they want to put something in a too hard box. Do you know what I mean? I mean, it's patriarchy. It's not mysterious. Do you know? It is very obvious what, what's causing these behaviors, what's enabling women's poverty enables abusive behaviors, from the beginning, and it always has. So I think it's about grasping the nettle of talking about what the problem is, and then looking at how it plays out in people's family and personal lives, and that's that's why it was so easy to put domestic abuse in the it's a private matter, it's a family matter. We don't, it's not a matter for public legislation, and that's one of the that protected a lot of vested interests. So I guess what I would say is you can call it culture, or you can call it skills, but or you can call it knowledge. But I actually do think that until we change the realities of the oppressions that children and women live with, the culture will continue to consider them less, because they are, I mean, in the way our cultures work. So I guess what I would say is just grasp and do the things that you can do, and that will change the culture, quote unquote. So make sure that you're doing everything that you can do to make transparent how gender and inequality works. And I think there's a number of opportunities for us. All of us need to do work around that, especially around race, around children's rights, around the areas where even more marginalization and oppression happens. But unless we're very explicit about how we do that, and we gather data about it from the beginning, it's going to be a talking shop, I think. So training is necessary, but not sufficient. It needs to be implemented with an implementation structure that holds everybody accountable for doing what it says on the tin. And it needs to be evaluated rigorously, independently, usually. And how to change courts is still in the too hard box for us. We've tried a million different things. We did training with the Judicial Studies Institute, and trained every sheriff in Scotland around the new domestic abuse law. From the evidence between the evaluation that Claire's crew did and all of the things we've been hearing from women and children, that has made almost no difference. So that it just proved my point. And we were involved in the training. It was a good training. It's just not sufficient by itself. So I think so much of the law is good. And I was at a criminal justice committee meeting recently where they were reviewing implementation, and they were like, well, what should we change in the law? And everybody around the table said, it's not the law. The law is good. They're really, I mean, except for the child aggravation and the co-victims thing, which I have, of course, from the beginning said was a mistake. But I do think that what we need to do is to be bolder about saying what has to change in the way our institutions operate, all of our institutions. And that sounds like, a social movement rather than a single implementation of a law. But it requires us to harness all of the energy and the passion that the women's movements and the children's rights movements in our countries have built over decades in order to make this work, I think. All right, I'm off of my soapbox. What else did you want? Oh, health, education, welfare. Same stuff all applies to them. I just spent some time working with Carolyn Bruce as the head of the trauma-informed training in the National Health Service here in Scotland. And we talked about the importance of embedding people's understanding of multiple oppressions, but particular how gender runs through experiences of trauma. And without that, trauma-informed is useless to women and children living with domestic abuse, because it's blind to most of what their experiences are. One more thing. So the issue around continuing and ongoing abuse, rather than the way our law is written, is 2 incidents or more. And I've always been a little uncomfortable with the fact that we still had an incident-based focus, I guess. But I could never think or suggest, and at least Sam, I know, and I were both involved in discussions with the bill team as the bill was being developed about how to operationalize what everybody was saying into a piece of legislation. But I think it's really important to, and absolutely, domestic abuse and coercive and controlling behaviors are 24/7 behaviors. They're not incident. However, we want something easily evidenced and proved in court. And I think that it was brilliant to come up with the 2 incidents, because everything I know from prosecutors say, when you're looking at coercive control, there's a million incidents. Do you know what I mean? And in Scotland, we have this weird and archaic thing called having to corroborate, which makes, I'm sure, police officers' lives very difficult and everybody else's lives very difficult. But the reality is, for really good fiscal, so prosecutors, what they say is, if the evidence is gathered appropriately, and that's a really big if, there is so much evidence that we can bring into court about the behaviors of the perpetrator, that it's so much easier to prove than previous offenses were. So, but you have to not tie their hands by how do we define a consistent and ongoing phenomenon? And I think I would just caution putting it in the law and making it more difficult to prove. I'm shutting up.
Thank you so much, Marsha. Sam and Gillian, Tracey, we might turn to you. Could you take us through the initial training of 14,000 Scottish police? Tracey, I know that was a huge project that you worked very, very hard on. What did that look like? What are the plans, if any, that you have for ongoing training and education? And what have you learned so far in regards to the development and delivery of that training? And I suppose a little bit of an add-on from what Marsha and Claire were saying, how do you educate police on the gendered aspects of that offence?
Obviously, you want to come in first before I go over the training?
I'll probably come in just with a couple of observations, Bridget. Marsha and Claire both know me, and I never defend the police, because you said at the start it was an international gold standard. No, it's not. We have moved on. It's not a gold standard. There's still a lot of work to be done. There are a few points that Claire and Marsha made that I would wholeheartedly agree with, and a couple that they'll not be surprised to learn that I don't necessarily agree with, and I do have to defend a tiny bit. It's training is not the panacea for us. It's not Marsha, it's maybe not the best term for any of us, but it's not the silver bullet. Because it has to be reinvigorated and refreshed all the time, and there are other impacting factors on that. But not just that. It's already been mentioned and touched on that societal attitudes, and actually victims themselves don't always recognise what abuse is. Well, they're members of the public, and the police are drawn from the public. So if it's difficult for victims to understand and recognise, it can often be difficult to train police officers to understand and recognise, because they're drawn from society, they're drawn from their communities. So the attitudes that they come in with, we have to change. The police, strategically and tactically, and mostly operationally, but not all of them, recognise that it is a gendered issue. And I think that's why we have things like proactive policies for policing domestic abuse. That's why COPFIS have a pro-prosecution policy. We do get criticised for that sometimes, because some research, and Marsha and Claire support the fact that it's gendered, and we need to respond to the fact that there's gendered dynamics in there and there's an imbalance of power. Other research recently suggested that we're making it worse for victims by doing that, because we're disempowering them. So the police sometimes get caught in the middle because there's contradictory opinions out there. And it's almost like you have to remain in the middle and apolitical and just try and do your best for every victim that you come across. So sometimes that can be very, very difficult, to be stuck in the middle of contradictory pieces of research. And in terms of the research, Police Scotland and I do, and my team do, embrace an evidence-based approach to how we police this. So we're always looking for more and more research. I think the difficulty for us is the research sometimes kind of a small data sample necessarily so clear. We've discussed this, but we get 148 reports a day. So trying to respond to 148 reports of domestic abuse every single day on top of all of the other calls that the police get can be hugely challenging. And then training 14,000 frontline officers, but actually every officer got DAMS training right up to the chief constable, is a huge undertaking. The training was evaluated, and I'll let Tracey come on to that because she was heavily involved in it, and it was evaluated positively. But for me, the important bit is it wasn't delivered by police. So it was jointly delivered by our partners in the third sector and specialists and experts, because the police are not experts in dealing with victims. They're supposedly experts in investigating the crimes and offences. But I've kind of touched on the difficulties that we get there. The figures have come up slightly, Marsha. We're still not brilliant, but it's 7% of reports. So if we get 60,000 reports of domestic a year, less than 50% of them will have a criminal aspect. We also record non-criminal domestics because occasionally then we can identify a pattern of behaviour from all the non-criminal and ultimately will achieve a DASA offence. But from the ones that are reported, 7% of them are DASA. Bearing in mind, our Section 1 will get recognised and identified on there. It's not retrospectively applied, and we get a lot of people that we engage with who are reporting non-recent domestic abuse as well. And we're not allowed to apply that retrospectively. And of those 7%, and these are the figures that Gillian manages, so she knows this much better than me, but over 70% of them result in a report to the fiscal. So we gather enough evidence. And the evidence bit's another bit that's challenging, particularly in the training, because Claire's research identified to us that victims felt they weren't getting involved enough in contributing in the evidence building phase. Some of the other research recently says victims felt they were being asked too much to contribute. So again, it's about finding the right balance and making sure that the training delivers the right balance that's actually victim-centred. And we're perpetrator focused in terms of arrest and perps, which is always our focus every day, is to actually deal with the person that's causing it and the root cause of it. But a victim-centred approach, which is why we engage with everybody else. But police and justice, we say this all the time, in isolation are not going to resolve this. That is a whole societal change that's needed, and probably generational change, but we can't fix it in isolation. And that's why we work with Scottish Women's Aid, we work with all the other third sector partners, and we work with academics to try and improve it as best we can. I'll probably finish that by saying, no, I'll still not defend it. It's still not platinum standard. It's not where we want to be, but in 30 years of policing, there's a huge change because we no longer tell people to go to their mothers for the night or to go to their pals or just exit them out of the house. It's dealt with as a criminal matter, and we are trying desperately to get police officers to recognise that. And yes, it's a slow shift, but at least it's a shift in the right direction. And I'll shut up now.
Gillian, did you want to jump in there?
Yeah, it's just before Tracey goes on to the really important part around the domestic abuse matters training, because she was involved in that from the start and the evaluation, just where we're kind of going forward around training. We have renewed our domestic abuse matters training licence. You know, we did have those 14,000 officers that were trained, but we need to continue that training, and it will be renewed annually. We also have 585 domestic abuse champions across Police Scotland, and that's across all business areas, so they can continue to support that training within their own policing divisions and support other divisions if they are needing a bit of assistance. We had a bespoke Train the Trainers event towards the end of last year during our 16 days of activism, and that resulted in 17 officers receiving the training around domestic abuse matters, domestic abuse champions, but also we have a new resource called You Me Together, which we produced with Education Scotland, and that will focus on domestic abuse in young people's relationships, around that coercive control, healthy relationships, and signposting them to partner agencies for support. But we also recognise we need to keep our training up to date. It needs to be relevant, because we see that, you know, it isn't a private matter. It is very much out there in the public domain, but we see that offending can move more towards that virtual space as well, especially when we're seeing how young people are communicating with each other, even that intimate image abuse that's out there. But also our probationer training. Our probationer training is actually, you know, it all goes through the Scottish Qualification Authority. It's aligned to the modern apprenticeship in policing. So we've actually increased our inputs on domestic abuse to our probationer training, and Tracey has also been fantastic in going in and making sure the staff there understand, you know, how that delivery should take place and providing support, because she's also based at the Scottish Police College. So we're continuing to monitor our training. We continue to work closely with the Scottish Police College, and we have been working with Safe Lives in relation to 6 new modules that we'll be putting out there across our own intranet, and it won't just be for domestic abuse champions, but it'll be for every officer going forward. And part of that will include our DASA training and look at the effects on children as well. We're also looking at how we record our vulnerabilities. We have a standalone vulnerability database that records all concerns around adults, children, domestic abuse. And where we have a bespoke DASA offence, we'll add a Y aggravator to that, you know, if there is a child involved in that offence. And we're doing some upgrades to our system to make sure that the officers are actually recording that child aggravator against the DASA offence correctly going forward. So I'm hoping that will also improve the statistics that we give to Crown, because we know we don't always get it right. So we're making sure that we're continually reviewing our practice and our processes and making improvements, and working closely with our partner agencies that are on the screen, and also the Crown Office and Procurator Fiscal Service. So that's really the main thing I wanted to say just now, sorry.
No, thank you so much. Tracey, talk to us about this training.
Thanks, Bridget. The first thing to say about Domestic Matters Scotland wasn't just a one-off piece of training, it's a change programme. So the Scottish Government funded it, and Safe Lives were the charity who worked with Police Scotland. So they came into our organisation at the start and did a health check, then we looked at training, and then they did a sustaining change workshop. So that was working with our senior managers and local policing divisions to make sure they could support the staff and all the change in culture and attitude. So the training, there was 3 stages to it. There was the pre-learning, and that's the e-learning package. And that e-learning package is still available to officers when probationers, like Superintendent Faulds was talking about, the work they do at the college. When they go back to local policing and division, they must do a certain number of training packages, which is essential, and that package is essential. So even though they get domestic abuse training at college, they still have to do this package once again to refresh that before they go out and start doing incidents. And that was delivered to all police officers in Police Scotland and staff. So we weren't just looking at police officers, we're also looking at staff that work in our organisation. That then takes us on to the face-to-face training. And it's a full day classroom training, but it's a massive commitment to the organisation. As the boss already touched on, the demands that in terms of calls that they're going to have to release 14,000 officers started on face training was a huge commitment. And the Chief Constable, he acknowledged that domestic abuse is an absolute priority. He backed it. He attended the full day's course. He gave up a full day to training, and every member of Police Scotland's executive attended the training. So it was a massive bit of support. It sent out a clear message that, you know, it was a priority, and it didn't just focus on the new legislation. Yes, that's incredibly important, but it's about recognising and responding to domestic abuse. So we looked at the dynamics of domestic abuse, how it impacts on children, how best to respond and investigate, gathering evidence for domestic abuse, not just the DASA, but all crimes, including financial abuse, stages of coercive control, helping them understand why victims find it difficult to leave an abusive relationship, because that could be a barrier that officers find difficult to understand. And as the boss says, officers are our members of society, and quite often society say, why don't they just leave? And it was helping understand, you know, sometimes it's not safe to leave. And that's a really important message when they're dealing with victims. They also looked at perpetrator tactics and how perpetrators can try to manipulate officers when they're attending at domestic abuse. We also looked at safeguarding of victims and children, and things like technical use and how that can be used to abuse victims. So it's a huge wide ranging subjects that were covered during the day. As the boss said, every session had 2 trainers that was dual delivery every single session. A police officer who can come in and talk about the investigation, evidence, but subject matter experts were the key trainers. They brought the voice of the victim into the room. They all had to have a role where they worked with victims and family of domestic abuse. And I'll be honest with you, when it actually came to training, the police officers will want the cops to stop. Like, yeah, they understand about gathering evidence. We want to hear from subject matter experts because they found it incredibly insightful and they learned so much. So the evaluations, there was forms filled out in every single session, and I think the number of forms were returned, some that probably went straight. We had over 13,500 forms returned, and what they looked at was their understanding of all the learning outcomes at the start of the day and where they were at the end of the day. So it was incredible. I have to say, some of the forms, one of the last questions we asked, how much would you recommend this training to one of your colleagues back in division? So 0 to 10. The last session I delivered, I had 27 folk in the room, and I was gutted because I got 1 9 because the rest were all 10s. That is how much folk bought into this training, and they went away and they actually spoke to their colleagues, and it was like a ripple effect. I don't see that we trained 14,000 officers and staff because they're all going home, speaking to partners, speaking to friends, speaking to siblings, and talking about dynamics of domestic abuse. So it was a massive ripple effect, went much wider, and we were actually getting emails in from officers saying, I did this training last week because it's quite reflective training. It was very immersive, a lot of facilitation. It wasn't didactic. It wasn't about speaking to them. It's about getting them to engage, bring their experience from being police officers into the room. But they will send me emails, a week or so later saying, I went away, I spoke to folk, I'm actually educating other folk. I went to a call, I did this, I asked this question, how much different it was. So, as I said at the start of the call, I've got over 30 years service and I should be retired. This is the proudest part of my police career, knowing what a difference we made. And as the boss said, 30 years ago, when we both started this job, we started at the same time. How we dealt with domestic abuse to where we are now is night and day. But we're not perfect, we know there's a way to go. And that's why I'm happy to get involved with the folk at doing the training in New South Wales about the learning I got from it. But as the boss says, it wasn't just about that one-off training. It's a change programme, and it's still ongoing up nearly 5 years later. We're still building these packs. They built the network of domestic abuse champions, and these were all folk who were volunteers. They wanted to come back and do a full day's training. It was about folk being told, you must do it. We didn't want folk who were voluntold. They all were really committed, and the enthusiasm they brought into the room was incredible. And they've been going away, and it's that peer-to-peer support, helping folks do a better job, recognise when they don't do so well, and speak to them and say, you might not have wanted to ask that question, that comment wasn't helpful. And as the boss says, we're continuing to do the work to support that at the moment. And as a team, what I say is we were really fortunate that the bosses made the commitment to put a team dedicated to it. So when the legislation came live, we went around all the policing divisions and did support. We did a roadshow, went across the whole of Scotland to help them understand how best to use the legislation. But that was through really close work with the Crown Office and Procurator Fiscal Service. What were we doing really well? Because it's always good to give folk good news. There's no point just saying when you get it wrong all the time, browbeating folk. Telling them when they're doing really good bits of work and telling folk about case studies, where it was used, where previously they wouldn't have been able to criminalise it. So that was really, really important. And we offered an on-call service. So anytime somebody had an incident or investigation and were unsure what they needed to do, for the first few months, we had somebody available 24 hours a day at the end of the phone to help and support them. So I think that was really key in developing the training. In terms of evaluation, it really was incredible. I've not got the final report to hand, but some of the learning outcomes, we're talking about 96% of officers, feeling much more confident how to recognise and respond to domestic abuse. They start off quite high, but when you're getting to that level, and I think what was really important is make sure our staff recognise it as well. They're often the first point of contact in the journey for a victim. So when they phone into a control room or go into a police station, start asking advice, that initial response by member staff can change absolutely everything. So for me, I thought getting staff involved was a really key part of it. I probably went on about it a little bit too much. I did get quite passionate to speak about Bridget because I do think it has made a seismic change for the force. And folks still speak to me, still stop me and still say it's the best bit of training we've ever had. And the commitment to get the full day's training in a classroom rather than just doing an e-learning package was really important. but we had to do the e-learning package. We recognised we couldn't get through all the officers in time for implementation. You're talking about your timescales February next year to try and get everyone trained and up to speed. We knew we had to get something there, some training, but they still came in. It's prerequisite before we can train. You had to do that package, and you had to do it before the Act went live.
That sounds absolutely amazing, and thank you so much for sharing all of that with us. We're, as a state, in the middle of developing all of that at the moment, so hearing all of those insights is so incredibly important for us to learn from. Could any of you share any other lessons that would be valuable for New South Wales? We've got a few minutes left, and it would be great if we've missed anything that you think that we could learn from. Marsha.
I'm not sure. I guess one of the things I would suggest that you look at really carefully from the beginning, because it's come up repeatedly in meetings about implementation for us, especially over actually just the last couple of months, is the failure to design the way our courts and operate so that there is information flowing from criminal cases into civil cases. And I think everybody, I'm seeing the nods around the Zoom room. It's really obvious to us that unless that the child aggravation is not really working the way we had hoped. Well, the way the government said it would, and way we had hoped, because we didn't get co-victim status for children. Which was that when perpetrators apply for child custody and visitation rights, the information about what those perpetrators did in the context of the domestic abuse case doesn't flow into the child contact hearing routinely and consistently and reliably. And so then we have a lot of decisions that are based on a supposed assumption, which is not supported in law in Scotland, may I say. It's an assumption made from patriarchy, not rather than from the law, which is that children are better off seeing both parents. Now, that is true when both parents are positive influences in their life. But we even know, despite putting domestic abuse aside, when there's high conflict in a family because of the divorce or other things, joint custody is a terrible idea, and it's not good for children. There's lots of research evidence for that. So, and when you put domestic abuse in the mix, of course, it's even more toxic. So, but what we had hoped with the co-victim request was that then when there were child custody cases being heard, it would be possible for the mother to say, look, this man has been convicted of abusing these children. You need to think very carefully and demonstrate how any contact with them would be in their interest, because it's in the paramount interest of the children, which is the bar that we're looking at in those cases. So I would say that it needs to be an explicit, aim in terms of the way the law is drafted and all, but really more importantly, how it's implemented in terms of the cross. And obviously different countries are different. I'm doing some work for the Council of Europe and Turkey right now, and their family law protection orders are separate from their custody orders, which are separate from their criminal cases, which are separate from something else. So I don't know exactly how in New South Wales it works, but I do know from everything that I've heard from colleagues over there that child contact is a problem there as well as here. So I would really, really recommend that you be proactive about how to manage that, both in the crafting of the law and in the plans for implementation. And then I guess the other thing I would say is that we often don't, and Claire references. We don't talk about sanctions very clearly. And one of the things that we have is we've just ratified, the UK has just ratified the Istanbul Convention. And there's some very clear language in there about sentencing needing to be proportionate to the gravity and the impact of a crime. And there is absolutely no way in Scotland that a community disposal protects women and children or is proportionate to the harm caused by a perpetrator of domestic abuse. And I don't think anybody will argue with me too much about that one either. And it's a matter of convenience for the country, because it costs a lot less to give them a payback order than it does to put them in jail, and I'm not a big fan of throwing people in jail. So that's not the only alternative. I think there's lots of other ones, like, very robust electronic monitoring, like intensive bail supervision, intensive supervision. There's all kinds of other ways that can provide more safety than what women and children are getting now. So I would look really carefully at what the sentencing guidelines are for your crime, and this will be your chance, because there's no way in hell we're going to get that change significantly in Scotland once the law was passed. And in high court cases, it went up to 14 years, and everybody went, "Oh my God!" But the vast 85% of our cases are not heard in the high court. So now we have a maximum sentence of 1 year. And one really interesting observation from some of the evaluation data that Bridget, I know, is sitting in your inbox, was that when you look at cases where there was a custodial sentence in summary court, the maximum they can give is a year, and something like 364 days or 63 days, 1 day under the maximum, is what the average sentence is, which will tell you that the sheriffs don't think that's high enough either. So, okay, I'm done.
Thanks, Marsha. Claire?
Thanks. Yeah, I agree with that. Just the importance of support and advocacy for any victim and any witness, but also for associated children who might not become child-sighted witnesses. And as Sam said, a lot of cases don't go any further, but as soon as we know about the women and children, we need to look at what kind of holistic support we can give them. And at the moment we're not. It's still kind of, for some it's quite risk-based, or it's based on whether they're actually part of they're actually a witness in court. Whereas we have got a lot of people within families that aren't getting immediate support when we know about them, and we know how important from our work over years as well as our research it is. And that came out as the single most empowering factor, but also that it was limited, that it wasn't early enough, especially for children, that it wasn't long term enough, that it didn't include mental health work, which it doesn't. It's very targeted on rights and information, which is good. But the holistic support that some organisations offer, including Women's Aid, but also some were asking for very specific mental health support and trauma support in the longer term. And of course, we have problems with wider health and especially mental health support for people. And just to echo what Sam said in terms of public awareness, thinking about that now, the national messaging on the Act to the whole of society, and actually just that culture change in terms of what is domestic abuse, to change that kind of understanding, and to find a way. There is mixed evidence about how involved people want to be, but what they're saying in the case, but we are not finding a way of telling the story, not just the police, like us as services, and then the courts, the prosecutors, when they're being cross-examined in court, and somehow we are not finding a safe, quick way of victims and witnesses telling safely and with the least trauma possible the whole story, and then being able to move on. So we need radical change for that, and not just for children, but for adults and children together as co-victims. So yeah, that was a big message from us.
Thanks so much, Claire. Sam, Gillian or Tracey, did you have any parting thoughts?
No, just the only thing I would say is that it does need partnership working, effective partnership working, even from the outset when the legislation was being developed in Scotland. And many of us sat around the table in workshops many times, and everybody contributed, which is why it's still not perfect, but at least it's deliverable on the ground. It's something that we can get better at delivering, but that means that the third sector and all the statutory agencies have to sit round the table and they have to work together, and that's what made this effective when the legislation was first developed. So it's not Scottish Government, it's not the police, it's not the Crown, it's not the sheriffs, it's not the judiciary, it's everybody, it's the people that work with the victims and the children, and then the people that have to deliver the law and enforce it on the ground. Very much a partnership approach to this one.
Can I
And
really
if you get money to
support that?
co-locate people, even better.
Exactly. I totally
Agree.
support that. And as a matter of fact, we were talking about it. You got somebody new, Sam and Gillian and Tracey, whose name, of course, has just gone out of my head, who's come up from down south, who I met the other day.
Jane
That
Connor.
was it. Yes.
Yeah, new boss.
So I met with her and Malcolm Graham, and who's another police officer. I was trying to describe to her how partnership working works in Scotland, and I described to her that meeting and that Anne-Marie Hicks, who was then the specialist prosecutor for domestic abuse, convened in the College of Prosecution in Glasgow as the bill was being written, which included Sam and myself and somebody from Assist and somebody from a variety of, other, I think there were about 6 of us.
And Amos, everybody was here.
Yeah.
We were all there.
And we were all like, okay, how do we make this work? What's the very best we can possibly make a law? And we were all not naive. We knew that a law is only as good as its, as the communities that implement them. But the fact that we were able to work with the bill team and that we were able to come pretty much with a unified voice. And when there were hearings in the Parliament, I would sit next to Sam, and on my other side would be Anne-Marie Hicks from the Crown Office, and we'd all be saying the same thing. Yes, we can prosecute this law. No, this is not the nanny state. No, and as Anne-Marie said, if you pass the law, we'll prosecute it. And Sam was saying, if you pass the law, we'll police it. And I just think that the reason people call it the gold standard was because it was developed carefully with victims' voices from the beginning in the center of it, but also in that context of partnership working. And I will say that one of the mistakes that the government made, and there's nobody on this call who's responsible for this, is when they put together an implementation board, they didn't include all of those partners. All they included was the Crown Office and the police, and maybe the court service. And I think that was a big mistake, because we could have fed data in from the coalface a lot sooner. And it wasn't, like I said, it wasn't anybody's decision here. And I would hope that they would have learned from that.
Wonderful. Thank you so much, everybody. I think that there's a lot for us to learn from everything that you've said today, and it's an incredibly interesting discussion that we've been able to have this morning, your time. So I really, really appreciate the time that you've put in this morning to come and speak with us. So I am just going to stop the recording now. So thank you very much.
Thank you.